When buying land for development, we need to think about restrictive covenants. And just as in a residential transaction, what we do is as follows. There might be easements that exist that are noted on the title or referred to in a conveyance that don't really affect our client at all. So we're buying a residential development site and there's a restrictive covenant that says you're not allowed to sell alcohol or manufacture alcohol on the land that's being sold. That's not going to impact on us if we're selling houses. If, however, we were creating an industrial estate and we had a prospective tenant that was a brewer, then it would be an issue. If we've got a commercial site and we've got Marks and Spencer's or Tesco that want to go on the site, a covenant that precludes the selling of alcohol will be an issue. Restrictive covenants are binding on owners of land if they are negative in nature, if there is land that benefits from the covenant, and if the covenant is protected in registered land, protected by notice in the charges register, unregistered land protected by land charge. Therefore, when we're buying land, if there are restrictive covenants, is this restrictive covenant going to impact on our objective? If we're going to sell or develop the land, might it impact on whoever we're selling the land to? Are the questions that we must ask. We must determine if the covenant is enforceable or not. If we're not sure, then we can take out an indemnity policy, a title indemnity policy that will cover the cost of bringing a claim or defending a claim, and will cover the cost of any difference in value between the land that wasn't burdened by the covenant and land that was. Where we're dealing with development, we should always explain to our clients the availability of an application under Section 84 of the Law of Property Act 1925, which enables an application to be made to Land Tribunal to vary or remove covenants. So just because a covenant is sitting on a title doesn't mean it's stuck there forever. We might be able to approach the person that has the benefit of the covenant and buy it out, or we might be able to make application under Section 84 for the covenant to be varied or removed. This case of Davis and Dennis is interesting because it shows that covenants can have amazing effect, far wider than originally thought. So this was a covenant preventing nuisance, so preventing neighbourly noise, etc. But the Court of Appeal said it was also capable of stopping a development. A neighbour wanted to build an extension on the house, and the court said, well, if you do that, you're going to create noise and nuisance, which is exactly what this covenant is designed to do. So although the original parties clearly didn't intend it to have wide-ranging effect, the reality was that it did. We have to ask ourselves who's burdened by a covenant, and always the original covenanting party is, but subsequent owners of the land could also be burdened by it. Restrictive covenants, as I've mentioned, have to be protected by notice in registered land or by a land charge. But just because a notice is protected by notice in a land registry charges register does not mean it's enforceable. Very important point. Just because the land registry's protected a restrictive covenant by notice in the charges register does not automatically mean that that covenant is enforceable. Your job is to check to make sure whether it is or it isn't.